This is Las Vegas Real Estate Now, where we bring you the 3 E's: educate, empower, and engage. I'm your host, Harvey Blankfeld, along with our co-host, Shelley Brown, and we've been selling homes here in Southern Nevada since 1988. Shelley and I are also very proud to be part of the Real Estate Radio Network. That is a national network of local real estate professionals delivering timely, balanced truths about local market conditions. We also have John Morgan from Equity Title. He's the Vice President and Chief Title Officer from Equity Title, and he's been working in the title industry in Las Vegas for 28 years. John, tell us about the homestead law. Tell me how that works.
I'd be happy to. So, the homestead, or the phrase homestead exemption, applies or is used primarily to describe a state-mandated, and it varies from state to state, that claims that, or states that your primary residence that you live in, the home you live in, is cannot be forced to go to sheriff's sale. Right. In the event that a judgment is obtained against you. If you, for whatever reason, find yourself in a position where a creditor has a money judgment against you.
Right.
And it doesn't apply to all types of judgments, things like child support.
Or your mortgage.
Doesn't qualify. Voluntary liens that attach to your property, like a mortgage that you signed for.
Right.
Those obviously wouldn't be included. We're talking here about involuntary judgments, things that might arise from a car accident, things that might arise from from credit card debt. When a judgment creditor is able to obtain that judgment against you, they are also able, if they choose, to force the sale of assets that you own at a sheriff's sale, and use those proceeds from that sale to pay down or pay towards the judgment. And so the idea behind a homestead exemption is that there's a fundamental belief in our state constitution, it's there, from 1864.
Okay.
That says we don't want to have residents, citizens in our state faced with the prospect of losing their home. The exemption amount in Nevada is actually very, very generous. It's $550,000 of equity.
Wow.
And so, by equity, we mean the difference between the mortgages against the property and the market value.
You said it's $550,000, but is it different if you're single or married? Does it matter? Does it have an impact?
No, there are limitations on who can file for a homestead protection.
Okay.
And part of what you need to do is to execute the Declaration of Homestead form. It's a one-page form.
Right.
It basically says that you own the property, that you live in the property,
right,
and that you're claiming it as your primary residence.
Right.
Very simple form to fill out, but the need to record it is built into the statute. So, so it's in order to qualify for the $550,000 exemption, you need to take that step. It also comes into play in the event you file a bankruptcy petition too, because not only do each state has its own set of qualifications for homestead exemption, but there's also a federal homestead exemption as well.
Huh.
And so, bankruptcy, when you file bankruptcy, you're dealing with the federal bankruptcy rules. And the bankruptcy court has actually said that they will honor each state's laws regarding homestead exemptions. You can still record that Declaration of Homestead at any point prior to the sheriff's sale. And as the judgment debtor, you're going to know when that happens.
Right.
You have to be notified. So that date for the sheriff's sale won't sneak up on you, and you have until then to go and record that homestead to stop the sheriff's sale from occurring.
You've been listening to Las Vegas Real Estate Now with hosts Harvey Blankfeld and Shelley Brown. Please tune in every Saturday at 11 a.m. right here on News Talk 720 KDWN.